Hello everyone and welcome back to our channel. My name is Malescu and I am the owner of Malescu Law, a law firm based in Miami, Florida, specializing in business, corporate and US immigration. We can assist you with all your immigration needs regardless of where you are currently located or where you plan to go in the United States. Today we are going to speak about the new Trump administration restrictions on the adjustment of status applications. But before we get started, please subscribe to our channel by clicking the bell button or the subscribe button. On May 21st, 2026, the United States Citizenship and Immigration Services published an official policy memorandum effectively changing the way the adjustment of status applications have been processed. Now, as a reminder, the adjustment of status applications on Form I-485 are used by individuals with an approved immigrant petition who are in the United States in order to obtain their green cards while physically present in the United States, as opposed to going and interviewing at the US consulate abroad and obtain their immigrant visa and green card through the consular processing. Typically, there are about 600,000 individuals who are applying for adjustment of status in the United States annually. This new policy memorandum will effectively affect all the individuals who are seeking to obtain their green card through adjustment of status as opposed to consular processing. And this includes those individuals who are applying for family-based petitions on Form I-130 and they are looking to adjust status based on approved I-130s while in the United States based on marriage to a US citizen or green card holder or family relationship, immediate relatives of US citizens, and also green card holders and others who qualify under the family-based petition. Now, the policy memorandum is not only affecting these individuals, but is also affecting those individuals who are in the United States on various non-immigrant statuses, such as the F1 student visa, the J1 visa, or temporary work visas like the O1, the TN visa, the E1 visa, E2 visa, L1 visa, E3 visa, and any other visas that allow you to be legally in the United States, and you are looking to adjust status once you have an approved immigrant visa petition on Form I-130 or I-140 or I-526 or I-526E for those applying for the EB-5 immigrant investor program. So all these individuals, and including those who have been in the United States on humanitarian parole or other special statuses, all of these individuals are affected by the USCIS policy memorandum that was issued on May 21st, 2026, when these individuals are looking to apply for adjustment of status in the United States. Based on the new policy memorandum regarding how will U.S. Citizenship and Immigration Services adjudicate the adjustment of status applications moving forward, the policy memorandum basically explains that the decision to approve an adjustment of status application on Form I-485 will be treated as an administrative decision, and the USCIS officers are instructed to look at the totality of circumstances of the individual applying for adjustment of status and determine whether this specific individual warrants a favorable exercise of discretion in order to approve the adjustment of status application. And in doing so, the United States Citizenship and Immigration Services officers are instructed to look at various factors regarding the individual applying for adjustment of status in order to determine whether to approve the application or not. And some of the factors that USCIS officers will be looking at include whether you have violated U.S. immigration laws, whether you have violated the terms and conditions of your non-immigrant visa or status, if you have a criminal record, if you have been lawfully present in the United States on a long-term basis, if you have strong ties with family in the United States, if you benefit, if your work benefits the United States in any way, if you have left the United States when you were supposed to leave the United States. So based on your immigration history with the United States, they will be also looking whether you actually left the United States when your non-immigrant status or parole instructed you to do so, and you did not stay in the United States past the validity period of your stay here. And they are also going to look for good moral character, community involvement. So again, these are some of the factors that USCIS officers will look at when deciding whether to approve your adjustment of status application. In the event that the USCIS officer denies your adjustment of status application on Form I-485 based on an unfavorable exercise of administrative discretion, then the policy memorandum also instructs the USCIS officers to provide a written formal denial notice that also explains and does an analysis of the positive and negative factors that have been analyzed under the totality of circumstances test in order to determine whether or not to approve or deny your adjustment application, and basically discuss these factors and how the negative factors outweighed the positive factors in your circumstance that led to the denial of the adjustment of status. So the policy memorandum is instructing USCIS to actually issue a full analysis on how the officer reached this unfavorable exercise of administrative discretion. Now, the legal community is closely following the implementation of this policy memorandum, and more information will become available and things will become clearer as USCIS starts implementing in practice the policy memorandum. And in the legal community we will have access to more information to see how this actually affects applicants that are filing for adjustment of status. But there are some obvious risks when it comes to this policy memorandum, especially given the fact that there is an immigrant visa ban in place for a large number of countries, and also certain US embassies abroad are closed. So the risk there is that you can find yourself being separated from your family in the United States for a long time when going through consular processing if you are from a country that has an immigrant visa ban in place at this time, or if your US consulate or embassy is closed and is not actually processing any immigrant visa. So you can have families that are indefinitely separated until the family member manages to obtain an immigrant visa, which can be challenging for those with immigrant visa bans and those who are applying at US consulates that are closed, but also consulates that may also close in the future, which you would not know about at this time. And another aspect to mention is also that it is unclear right now what happens to those who actually have adjustment of status applications that are currently pending at the United States Citizenship and Immigration Services. And because at the time of application this policy memorandum was not in place, these applicants did not have an opportunity to actually attach proof of good moral character or other compelling information such as strong ties to family members in the United States or community involvement or any other documentation that could prove to the United States or could try to convince the United States Citizenship and Immigration Services officer to actually apply a favorable exercise of discretion in their cases. So that is up in the air. We don't know right now how these pending adjustment of status applications are being treated, but as I said, the legal community is following closely this policy memorandum and the implementation of this policy memorandum, so we will be able to do videos in the future on the exact practice coming out of the policy memorandum. This is all for today. Thank you so much for watching. Please subscribe to our channel, and if you need to get in touch with us, you have our contact information in this video and below this video. We will see you soon. Bye.